Hello everyone, welcome to Learn Law with AKP. In today's class, we will discuss delegation of authority under the Indian Contract Act 1872. A very important question arises in agency law. Can an agent transfer his authority to another person? Can an agent appoint someone else to perform the work given by the principal? The answer is found in the famous legal principle called Delegatus non Potest Delegare. This topic is extremely important for semester examinations and competitive law exams. Let us begin. Now, delegation means transferring authority from one person to another person. In agency law, delegation occurs when an agent appoints another person to perform duties assigned by the principal. The person receiving authority is usually called a sub-agent. However, agency is based on personal trust and confidence. Therefore, delegation is generally restricted by law. Now, general rule. One of the most important principles in the agency law is delegatus non potest delegare. This Latin phrase means a delegate cannot further delegate. When a principal selects an agent, the section is based on trust, skill, and confidence. Therefore, the agent must personally perform the work entrusted to him. As a general rule, an agent cannot transfer authority to another person. Now, the reason behind this rule is simple. The principal chooses a particular agent because of trust, experience, reputation, or skill. For example, a client appoints a famous lawyer to handle a case. The lawyer cannot simply transfer the entire responsibility to another unknown person without permission. The principal trusted that specific lawyer. Therefore, delegation is generally prohibited. Now, although the general rule prohibits delegation, the law recognizes several exceptions. Delegation is allowed when the principal expressly permits it. Business customs permit it. The nature of work makes delegation necessary. Emergency situations arise, or the task is purely mechanical or ministerial. These exceptions make business operations practical and efficient. Now, let us understand the concept of a subagent. According to section 191, a subagent is a person employed by and acting under the control of the original agent. For example, a shipping agent appoints a local representative to supervise cargo delivery. The representative works under the original agent's control. This person is known as a subagent. Now, when a subagent is properly appointed according to law, certain legal consequences follow. The principal becomes bound by the acts of the subagent. The original agent remains responsible for supervising the subagent. This arrangement is recognized by law because the delegation is authorized. If a subagent is appointed without authority, the situation changes completely. The principal may not be bound by the subagent's acts. The original agent becomes personally responsible for any loss. For example, an agent appoints another person without permission and loss occurs. The principal may hold the original agent liable. Therefore, unauthorized delegation creates risk. Students often confuse subagents and substituted agents. A subagent works under the control of the original agent. A substituted agent is directly selected for the principal. For example, if a lawyer appoints a local advocate with permission from the client, the local advocate may become a substituted agent. This distinction is frequently asked in examinations. Now, let us understand an important case law. In D. Bussche versus Alt, an agent was authorized to sell a ship. A question arose regarding the appointment of another person to assist in the transaction. The court examined the circumstances under which delegation could be permitted. The court recognized that delegation may be valid when it falls within recognized exceptions. Here, the principle established is although delegation is generally prohibited, lawful exceptions permit the appointment of subagents and substituted agents. This is a landmark case of on the delegation of authority. Now, let us quickly revise. The general rule is that an agent cannot delegate authority. However, exceptions include permission, trade custom, necessity, emergency, and ministerial acts. Remember these exceptions carefully because they are often asked in exams. Now, for examinations, always remember the general rule, the Latin maxim, the exceptions, the difference between subagent and substituted agent, and the important case law. These points are enough to write a complete answer. Now, let us conclude today's topic. Agency is based on trust and confidence. Therefore, the general rule is that an agent cannot delegate authority. However, practical business needs require certain exceptions. We also learned the distinction between subagents and substituted agents and studied the important case of D. Bussche and versus Alt. For examinations, remember the rule, exceptions, definitions, differences, and case law. Thank you for watching. If you found this video helpful, please like, share, and subscribe to Learn Law with AKP. See you in the next class.